morning, everyone, and welcome to this session of the LPEA Insight Conference. I'm Catherine Pogorzelski. I'm the country of the Luxembourg office of DLA Piper and also co-chair of the legal committee of the association. And I'm pleased to be your moderator today for this session. We'll be discussing today the 2025 Luxembourg and European legal and regulatory agenda. There will be an opportunity for questions at the end of the session, so I invite you to raise questions through the chat board on the right side of your screen. Know that you can also maximize the face of the person talking by just double clicking on the face. And now to start, so we all know that change is inevitable and regulatory change unavoidable. So consider how much the financial system has become intertwined with the environment. Now add here to the geopolitical forces at work, Brexit to name only this one, and look at the small sliver of sovereignty that remains in the bigger scheme called the EU. We now compose the menu for the coming 3 to 5 years. We have the new Green Deal, which is a big deal, and the financial services industry as an essential role to play here. We are still building the single market when it comes to fund distribution after more than 35 years. This gives you an indication of the complexity of the task. IFMD can be described as a success story. So does it really need a revamp? It was never meant to happen, but Brexit is 6 weeks away, and the financial services industry is nowhere to be seen. So what to expect now? Which brings to our small but very important pocket of sovereignty, our 1915 law and the Luxembourg toolbox, or how can we push way above our weight? So to tackle the above, I have the privilege of an expert panel composed of Silke Binard, investment funds partner at Linklaters, and also a co-chair of the RIFE and non-regulated AIF technical committee of the LPEA. We also have today Manfred Dietrich, partner and head of the Luxembourg investment funds and asset management practice at Norton Rose Fulbright, and also a co-chair of the IFMD review technical committee of the LPEA. And last but not least, Sebastian, Binard, corporate M&A and structuring and insolvency partner at Arendt and Medernach, focusing on PE clients, and also a co-chair of the corporate law technical committee and a member of its central intelligence committee. So now let's start with one of the very hot topic being ESG. So Silke, we hear so many things about sustainable finance, ESG impact, socially responsible investing, and equally so many different deadlines and requirements that might lead to confusion. So Silke, can you give us a high-level overview of the EU sustainable and ESG agenda as it's currently unfolding?
Thank you, and hello everybody. Thanks for joining. That's a bit of a challenge to explain in just a few minutes in the sustainable finance package of the EU. Let me focus maybe on the sustainable finance disclosure regulation, which is the one that comes first. That will kick in, as you hopefully all know, in March next year. There are other regulations also kicking in. One is already effective, that is the benchmark regulation. There's taxonomy coming after that, and probably it will never stop. There will be, after the environmental taxonomy, there might be a social taxonomy and other frameworks to come. So it is just the start of a story, and we cannot say at some point we will have done it. So I think, well, we will never reach that point. So where do we stand right now? The Sustainable Finance Disclosure Regulation kicks in, as I said, in March for all funds, regulated or non-regulated funds, and their managers, be it the AFMs or delegated managers. So there are several layers to look at, and when you go into the detail, it gets really complicated. So I'm trying to oversimplify today just to give you the insight, but hopefully you will all have started your ESG projects already. So you need to look at your funds, at the fund managers, delegated managers in the EU, outside the EU, Obviously, UK is a very special animal because they were supposed to apply the sustainable finance disclosure regulation, and now just a few weeks ago the FCA suddenly said, oh no, we will no longer be EU, so we will not apply the sustainable finance disclosure regulation. We may well look into an own UK ESG framework. But of course, if you do, for instance, manage a European fund, then you will be captured. So creating a total confusion on what will apply to which extent and what people need to do. So it's pretty complex. On the time perspective or timeline as well, it is important to note that closed-ended funds that are no longer in fundraising, while to some extent you can forget about them because you don't need to put any new disclosures in these funds. You're lucky these ones are done, and existing funds where you don't let any new investors in, they should be fine. However, if you have funds that are either open-ended or still in fundraise by 10th of March, you need to look at these, and it will be all funds. Catherine already said there will be different categories. You have what I call, and it's not a very precise terminology, but I call them the white funds, the light green funds, and the dark green funds. I was asked before if there is no color for social. I don't know one, but so I just call them green, light green, dark green, or not green. And your disclosures will depend on what category you put your product into, and what we call product scoping is really complex. Sometimes you're in the middle, in the gray between light green and dark green, or white and light green, and it depends really on the very detail of what you're promising to investors, what they are buying, what they believe they are buying. So not an easy task. Even when you have funds that may no longer be in fundraising, you may nonetheless need to look at your own policies, because the Sustainable Finance Disclosure Regulation applies at two levels. It's the products, the funds, or the management agreements, or whatever you may have, but it also applies at entity level. So you will need to look into your policies and website disclosures in all kinds of paperwork that needs to be up to date, and that needs to contain a specific number of disclosures. And you will need to comply with all the details that are required now in certain titles, certain format, and so on. So it's quite prescriptive. What do you actually need to do? It is two things, and again, I'm oversimplifying. It's sustainability risks. I always call it that is the inbound effect of ESG factors on your portfolio, on your performance. So if there are factors like environmental risks that affect or could affect your portfolio, because you have construction or companies in a risky area. So that is the inbound risk of sustainability factors on your portfolio, on your value. And then the other way around is the outbound risk or outbound impact. So what risk or impact do you create on ESG factors? Do you create any risks? What is the impact of your company, target company, portfolio company on the world around it? So inbound and outbound, that is really very simplistically what the disclosure regulation is about and what you need to disclose. I said earlier, you need to look at different levels. So for the products, typically you would put some disclosures into your PPM or into your agreements. You would update your websites. You will need to look into the reporting, but a bit later down the road. But at the entity level, there it can become really complicated. If you have, for instance, a Luxembourg A firm, typically they would delegate portfolio management either to European entities, then they're captured themselves, or outside the EU to UK, US, Switzerland, Asia. They may not be captured, but still you have your obligations in Luxembourg. So you will need to have a pretty close conversation with them to know what they are doing, what the product really is about, and how it will be run. What risks there are, both inbound and outbound, and how you deal with it. How can you inform investors about all that? It can be really difficult. Also, if you look at feeder funds, at fund of fund structures, be it group internal or external, because if you have your Luxembourg A firm, your Luxembourg fund, and the US manager, would they be willing to comply with European definitions of sustainability objective in a fund product? If they're happy to, you're lucky. If they say, well, I have my own definition, you will need to find your way around that. So it's very interesting challenges that are coming up there. I just want to say one word, because there has been a lot of confusion in the market. You may have read that the level 2 measures, so all the technical details, they have been postponed. So we stand with just the level 1 measures, which are to some extent high level principle based. On certain points, they're more detailed, and these should be fine. But the other way, where the regulation says, well, the technical standards will come out and will help you to know what exactly you have to do. Well, these won't be there by 10th of March, and you need to find your way. There are some actors in the market to say, well, there's a draft of the technical measures. I will just take that as an inspiration. I will pretty much comply, and I trust the final technical standards will be more or less the same. Others say, oh, that's horrible, these technical standards, they are so detailed, they are being challenged, including at Brussels level. There's pretty harsh criticism on certain points. I will not be overzealous. I will not apply these technical standards. They are not legally binding, so I just do it freestyle. I take the level 1 and I just try to find my way based on these principles. So we see everything in the market. It's either white or black on the middle. Everybody tries to find the right solution for the organization. So especially in the PE space, I would think I see many taking an approach, well, we don't want to be overzealous and comply with totally complicated, maybe to some extent inadapted standards that are being imposed on us, and we don't know if at the end of the day they will be adopted at some point. So they would rather take an approach for the time being where I can. I will not comply with the new rules. I will rather explain why I don't, because I'm waiting for the final rules to come in. Or I will take an approach that is already close to what I'm doing today. I will not try to be the best pupil in the class and to apply the technical standards by the letter. I will take an approach that is closer to what I'm doing when running the business, and see if actually the final technical standards will be the same as the drafts we have today. I must say, some of my PE clients are also still a little bit in the denial phase. So those of you who hear of the Sustainable Finance Disclosure Regulation for the first time today, maybe it's worth looking into it, and also starting the strategic discussions, because it's not only legal, it is also about strategic positioning. How do you want to be seen in the market? For instance, if you are in the middle between one of these categories of funds, would you wish to rather be more green or less green? Do you think that has an impact on marketing? How will investors perceive you? There are many investors, especially institutionals, who will ask you these questions, who will ask, are you dark green, light green? What is your approach to ESG? What can I expect from you? And what your sales team are selling as a product, well, that will define to some extent your success in the ESG market going forward. So I think there will be a shift, and it's not only legal, although we're in the legal panel right now, but it's also strategy. So it's time, I think, to really consider and look at it quite actively.
Thank you, Silke. It was very, very useful. And if I hear you well, there is one deadline to watch.
I think you're on mute. No worries.
Sorry. Yeah, no, I was saying thank you. It's very clear and very helpful. And I was saying also that so if I hear you well,
can't hear anything of what Catherine says.
You cannot hear me now?
We can. I can.
Okay.
I cannot. Sorry.
Okay. Yeah, no, and I was saying there is one deadline to watch, which is the 10th of March, correct? But we are still lacking some guidance on the interpretation. Sure. Yeah. So let's add a bit of complexity, but thank you. That was very useful. So Silke, if I may keep you for another very hot topic as well, which is the cross-border distribution directive and regulation. So on this, if I understand it well, the intention is to create conversions across all collective investment funds and regime, and to capture AIF, UVECA, Joseph, LTIF, etc., and UCITS with a fast approaching deadline in August 21. So for those funds launching now, it's actually tomorrow. In terms of key topics, what and how PE players need to prepare for that?
Yes, thanks, Catherine. Actually, that topic has somehow moved down on the radar screen. It was all we have been experiencing over the past few months. So I think nobody is really focusing anymore on the cross-border distribution of funds, directive and regulation. It's actually two texts. But it will be really important in terms of fundraising. So indeed, as you're saying, the idea was to harmonize the frameworks and also to overcome obstacles that have always been mentioned in the industry and that really made the European passports not very effective. So there are these two texts, and they try to really help the cross or pan-European distribution to improve, to be more easy, more harmonized going forward. So it is there are a number of points being addressed in these regulations and directive. I just want to pick one major point which is really important to this audience, that is the pre-marketing rules. So I guess probably all of you have experienced whenever you were trying to do investor testing of a future product, roadshows, be it only on strategies, you had to comply with the local rules in each individual country. And for some countries, just talking to investors about a strategy or a future fund you were intending to start working on, that potentially could already been seen as marketing, and there you had a pretty big issue because you cannot do a marketing notification as long as you don't have the product. So it was a little bit like the chicken and the egg question. So hopefully that will go away. Now we will have a harmonized pre-marketing framework. The good news is pre-marketing will be allowed in all countries. So that is very important. You can do investor testing and pre-marketing across Europe. The second good news is that the same rules and the same definitions will apply in all countries. You no longer need to contact 27 different legal councils in each country to know what you're allowed to do and what you're not allowed to do. You can rely on one framework. So that is great news. What are these rules? You can do pre-marketing for either a fund that is not yet in existence, you're still working on, or one that is in existence, that is set up, but not notified into that country. So if you have a fund and you want to test if Austrian investors may have an appetite, you can talk to them subject to certain constraints and see if for Austrian investors this could be an interesting product. You need to take some precautions, so not hand over subscription documents, not show them the final documents, but have some disclaimers on it. So yeah, that is quite legitimate, I think, to have some limits so that investors cannot sign straight away, but they see that it's only pre-marketing and not marketing. You will have to notify your home country regulator that you're doing that pre-marketing. So you will tell the CSSF if you have your fund in Luxembourg within 14 days from starting of your pre-marketing. So it's ex post that you're doing that pre-marketing and in which countries and what kinds of pre-marketing you're doing. And the CSSF will then inform the various other countries that you're doing this on their ground. Who can do it? Well, the AIFM are an appointed distributor. that shall be a regulated entity. So either MiFID firm, credit institution, management company, AIFM. So not anybody. You cannot ask your cousin to go out and screen the market, but you need to have some regulated framework around it. And the last really good news is that the regulation and directive foresee that no gold plating is allowed. So host countries shall not be allowed to impose additional rules for that pre-marketing. And that is hopefully the one that will really harmonize the marketing and pre-marketing across Europe. I just wanted to focus on that one. There are other points in that framework of cross-border distribution of funds. These other points are not without importance, but we have only a little time today. There are rules on denotification and what it triggers. So if you denotify a fund, you cannot start raising the successor funds the day after. Some of these rules. There are content requirements on marketing material, and there's a consultation on the detail that has just come out this week or last week. And there are other points like local facilities, a public register at ESMA level to facilitate all these things. So a few interesting points, but the one I really wanted to focus on is the pre-marketing.
Thank you. That looks promising, and definitely something that the LPEA is also working on. So willing to support the players. Thank you, Silke. So now on another hot topic, and I'm sorry that you keep saying that, but that's actually true. We live in a very challenging time, as you all know. So on IFMD2, and we all know that IFMD revision is long overdue. Brexit has certainly contributed to the delay, and the ESMA letter of last August did not make it better. But now the revision is there, so the consultation process is now on for until the end of January. And we don't know yet whether IFMD level 1 measures will be impacted, and everyone is hoping that revisions will be actually limited to the level 2, but it's still uncertain. So Manfred, you've been working with your technical committee on the ESMA letter earlier this year, and now you're working on the consultation paper. So can you give us high-level overview of the key topics that the PE players should pay attention to? Manfred? We cannot hear you.
No. I couldn't hear the end of Catherine, sorry. But
oh yeah, sorry. So Manfred,
if you can hear me, then yeah. I'm happy to jump on.
Yeah, so
yes, we have been in the situation that this ESMA letter was rather astonishing, and that was confirmed by the CSSF themselves in the last AFI conference, and this was not only concerning the letter as such, but also certain topics which were raised therein. I mean, for instance, on delegation, it was very clear that where all national regulators are put together in a gremium, that has never been raised as an item which should be discussed, or which, let's say, raises any problems. So there was, yeah, even on our regulator side, a really an astonishing situation. Now, the entire market has been astonished by the letter, not by the fact that there will be a revision of the FMD. And we will now need to deal with the consultation paper which is out. There's a, let's say, clear time plan for it, which has been delayed, as Catherine rightfully said. But it, in the end, concerns the entire system, more or less. So we have really a 100-pager to review. And we, as LPEA, work heavily on it in our working group. And we as LPEA are there to do that, and we are there to help our members to do it and to give the right responses in the best interest. I have just recently got a message that this morning there was a webinar organized by the Commission And one of the outcomes of this, let's say, a general outcome, is maybe to mention that at least there's a general, apparently, view that those who have been on the panel saw that AIFMD in general works well. This is already kind of a little good news, but nevertheless, we will need to run through the consultation paper very thoroughly. I probably need to reconnect because I can't hear Catherine, but I'll try to do that immediately.
Can you hear me, Manfred?
It's the battery in your headphones, maybe.
No, it's full.
You
Can you hear me?
You can hear Sebastian? Yes, we can.
Can you hear me?
Yeah.
Yeah.
And can
I'm
you
very
hear
sorry
me?
for that, but I already reconnected once.
Can Sebastian, Silke, can you talk to Manfred to see whether the problem is on my side? It's just for me, or?
Sure, Manfred, can you hear us?
I can hear you. I can hear Sebastian. I can't hear Catherine.
That's really strange. Okay, Silke, do you mind? Maybe can I ask?
Well, I did nothing.
Silke, can you ask Manfred just to run us through very quickly the different key topics of the IFMD consultation paper?
Happy to do so. So Manfred, Catherine just asked me to jump in and ask you some of the questions we have previously discussed. So I think one of the main points is certainly delegation and substance. So what is the LPEA view on that, and what have you discussed with your working group? Can you give us a little insight?
It's gone.
No, we lost him.
That's the time I jump in.
Yeah, you want to cover FMD?
Nope. I'm happy in my non-regulated world.
Manfred, can you hear us now?
I'm back.
Manfred, can you hear?
Yes, I can hear you. I can hear Catherine. I see her speaking now. I just reconnected. Sorry.
Okay.
Yes. The topics I would say probably we are now on. What are the main elements which is kindly set out in the consultation paper? So we have a very generic item which is scope. We have investor protection. We have delegation and substance, disclosure and reporting, investment in non-listed companies, of course, sustainability and ESG. Let's say the continuous item from what Silke already said, and then ESMA supervision powers in relation to NCAs. So, Catherine, I will then, let's say, kind of immediately start to jump into these ones, no?
Yeah, so maybe, Manfred, if you can just summarize those which are really the key topics for us in Luxembourg, and just explain a bit the point of attention for the audience.
Yes, I mean, in the scope, it touches first on a general functioning, but also on the license of AIFMs, including, let's say, certain items on the MiFID top-up, also the segregation, securitization against AIFs, and of course also sub-threshold AIFMs, and the question of own funds. So all of these items are certainly for the one or the other crucial and need to be carefully taken care of. The next topic, which is really, I think, interesting and important, is investor protection. Here we speak about professional investor reference, meaning the Annex 2 of MiFID II, questions around whether this is appropriate, and I think we have all certain opinions on that there might be some room for improvement. Then questions on whether retail investor access should be, let's say, made better. Now the crucial question is what kind of retail is meant, what is in the end then the professional investor setup. who will in the end be able to access AIFs, which on the other side then also has an influence on the question, well, do I need to deal with really professional ones, or is now there a need to adjust certain things into retail ones? I mean, there is also we paid very much attention that we do not run into a situation where a well-functioning system is a little bit jeopardized. Then we see questions around depository role and passporting, valuation when it comes to delegation of the valuation, the combination of the working together in the valuation, and in all of this, we should not forget that in the end, when it's about investor protection, also having a choice and being able to go on the market and see who is doing what, and not being confronted with let's say a limited number of service providers or managers is really an investor protection, because if there is only a few left over who can really do the business, then the choice is relatively limited, and I would say that is not to the interest of any investor, be it professional or retail. Next item, which has already been, let's say, I think running around the market for a certain time, is the delegation in substance, meaning further to the ESMA letter. There is a lot of questions around quantitative, qualitative criteria, maybe to set out a framework of functions which may be delegated. When we now look at the question of delegation, then also a potential passport of a depository is a little bit in a different light. Also at the Alpha conference already, the CSSF mentioned that it looks a little bit strange to look deeper into delegation rules or things which may be amended there, and at the same time go for a passport which would then additionally require coordination potentially between countries, additional concentrations, etc., etc. Item 4, disclosure and reporting. Also important because what should be reported to whom? And this concerns, for instance, leverage items, loan origination, or things like that. And the crucial question continuously coming up is there certain things which should be reported directly to ESMA, or is it something only the national authorities would provide ESMA? So the questions go around that, and I think an entire market should think about what would be the best thing to do, and to clearly set out what is also, let's say, in the interest of information sharing, who is closer to the business, who is closer to the entities which are acting, and at the same time addressing the macroeconomical interest of certain reporting. Then non-listed companies, investments, questions around is there sufficient transparency? What about the financing? Does there need to be an amendment when it comes to the treatment of these things? And is asset stripping prevention sufficiently addressed? On sustainability and ESG, I will be relatively brief, but the questions around there are more concerning the risk management and how to include that, especially addressing the ESG. And the items around that, how would AIFMs need to address this? And then finally, ESMA supervision powers and relation to the national supervisory authorities. We have questions around, is there a need for a direct supervision of certain entities, maybe by the ESMA, ESMA intervention rights, and then the powers of the national supervisory authorities on a cross-border basis, the sanctions regime, and whether the principle of proportionality is, let's say, always applied in the same way or maybe in a consistent way across Europe. So there is, I just quickly ran through the things because, of course, all of this is heavily discussed, and we are certainly not will not be able today to say it should be this or it should be that. I think we all make up our minds, and everybody who is contributing to that is very welcome. But it was just to give everybody a little bit of heads up in order to say there is a lot of things going on, and I think everybody will find something where he's concerned or where he's having things where he experienced certain things in the past and can contribute his experiences to that work.
Yeah, no, true. Thank you, Manfred. Indeed, lots to be discussed, and hopefully only level 2 measures will be touched. Thank you. So now let's move to the corporate law developments, and with this changing environment, European regulatory environment, Luxembourg needs to remain competitive. We all know that Luxembourg has been efficient at staying on top of the financial services industry changes, but looking at the pure corporate law aspects, the last modernization of the law on commercial companies goes back to 2016 and was actually 10 years in the making. So Sebastian, you are co-heading the Corporate Law Technical Committee of the Association. Can you give us an outlook of the current line of thinking, and so what's going on behind the scene that's relevant for PE players?
Thanks, Catherine. Thanks very much. Hi to everyone. I'll just start by saying that if you picture regulation as the skin of fund structures, then corporate law is definitely the backbone of those structures. And so I don't think I need to explain how important this area of law is for all of us. We sometimes forget it a little bit because it's I'd say quite flexible, and we make good use of it day in day out in our Luxembourg funds and companies. Now, that being said, if we go back to 1915, when our national corporate law was first enacted, if you go to the parliamentary works, you will see that this was really a matter of national priority, right, for the development of the Luxembourg economy. And where I have a slight sweet sour taste in my mouth is that it doesn't seem to be as much the case. Obviously, we have our reforms, but it takes a long time, as you mentioned, Catherine, and then we could be a bit more courageous, let's say, on some topics, and in order to get ahead of competition. Because the important thing is that there is competition, and there are other jurisdictions who are looking at what we are doing. I think when the partnership structures were revised in Luxembourg, we heard the PE industry in France looking at this very closely. They even have a vehicle which is nicknamed, almost the same. Its content is a bit different. We need to do this. I'll come back to that. I think what we want to do as part of the LPEA is trying to push where we can for slightly, let's say, faster pace of change, just to improve our corporate law, and especially improving it by bringing the ideas of the private equity world to it, again, where we can, knowing that corporate law applies, to a much broader number of persons and actors than those in PE, but still, we feel that those ideas are important. And so, LPEA will want to convey those messages to various authorities, through various working groups. That can be the Haut Comité de la Place, or through the Ministry of Justice, or Luxembourg Bar, Chamber of Commerce, or what have you. And I think that one message in particular, once again, that we want to convey is that Luxembourg corporate law must evolve on a regular basis, just to not only to keep its competitiveness, but to stay ahead of competition also, ideally speaking. So I'll give two examples. If you go to the, if you're familiar with the state of Delaware, in the US, it's a very small state, but they are very big in number of companies that are domiciled there, and even funds as well. Why is that? Well, there are a number of factors, but they're extremely, let's say, business-oriented and flexible in the legislation. They have excellent courts dealing with corporate law matters, but excellent legislation as well. And they have a sort of program, an annual review program, where they review their state corporate law on an annual basis, which is perhaps not something that we do, perhaps because of a lack of resources. And I think as an industry, we should be there to bring those ideas on a very regular basis to our legislators and governments. And then closer to us, if we look at Belgium, they've gone through a quite impressive effort very recently. So they completely revamped their corporate law by I'd say turning upside down some centuries-old principles that they had. So, for instance, they cut down the number of companies that are, or form of companies that are available to 3 or 4, which is totally the opposite of the model that we are taking in Luxembourg. I think we can still be proud of it. I still believe in the fact that we have those, 15, 20 odd forms of companies, funds, and such. It gives us a bit to think about and a lot of useful tools, but they just had the courage to take a very different model. And the second point on which they acted is it's a very technical concept, but on the legal theory under which you determine whether a company is a Belgian company or not, whether Belgian corporate law applies to it or not. Well, they completely changed the system. They went for the opposite of what they had before, and so I found that quite interesting. I think that's certainly something. Let's say the whole mindset that we can get inspired by. Now the question now is what can we do in Luxembourg? Well, I'd say first of all we can and will continue to develop our own tools. We have our own identity as a jurisdiction, but at the same time I feel that we still need to keep a close eye on what the competition does. And so the Corporate Law Technical Committee will want to do that, just to do some competitive watch. And I think for those of you who are part of, who are employed by GPs, who are in the attendance, I think we're very much counting on you to bring ideas of what you see in jurisdictions outside Luxembourg that you find good and that you feel that you cannot replicate in Luxembourg as of yet. There shouldn't be that much, but I'm sure that there are good ideas here or there, and I'll mention a couple in a few minutes. So please don't hesitate to contribute. Go to your regular LPEA contacts, bring in those ideas that you see that we could make good use of, and then share the good words with the Luxembourg authorities. Now, perhaps then just a few examples of what we could have, or how should I say, what we should have in Luxembourg. I mean, first, we expect that in the coming years there should be, we hope, effort towards the full digitalization of Luxembourg corporate law. That is definitely very much necessary as of now. I mean, if you are, and I'm sure a lot of you are users of Luxembourg corporate law, some things remain a bit complicated when you need to communicate with your shareholders or share information with your shareholders. And so you've all gone through the process of complying sometimes with unhelpful timeline and conveying periods. You need to send registered letters, which is really, especially in a COVID world, is something that becomes very complicated. You have to make publications sometimes. You sometimes have to attend meetings in person. You have to give access to your registered office physically to shareholders in certain operations so they can inspect documents, corporate documents. It's all really a bit too complex. It was probably very fine in 1915, but in 2020, not that much. And now, in all fairness, some of the provisions of the law have been partially digitalized or modernized in that sense, but not all of it. And so that's something that we'd like to focus on, obviously, while making sure that shareholders are adequately protected, but can still be contacted by electronic means only, for instance. it would be very much greener as well, because the stack of papers that are printed every year for the 50,000 odd companies that we have in Luxembourg is astonishing. I don't think it's good for anyone, so except the producers of paper, of course. Some of the concepts that we have on the map perhaps is a possibility to sort of formalize the issuance of dematerialized shares or even tokens. It's something where there are various working groups being active on, but at the level of pure corporate law, I think we will need that missing link just to say that we'll be able to essentially issue non-share securities or electronic tokens, let's say. Another possibility, another thing that came to mind was that, well, in the regulated funds world, very much sub-funds and compartments, and we're very jealous of that in the non-regulated world. And so we'd like to bring in the concept of let's say, compartments to holding companies, especially so-called master holding companies. We think it would be very useful. It shouldn't be that complicated to bring in because it exists already at the level of securitization companies. And so the concepts are there. Perhaps there's some fine-tuning to be done, but that's something that we would have on the agenda. Then also, like Belgium does, I mean, there's a much needed need to look into the criterion that we use to determine when a Luxembourg company is a national, is a Luxembourg company or not, when it is subject to Luxembourg corporate law or not, because some actors can feel that there's a very slight or perceived, let's say, lack of certainty. We don't think it's the case in practice, but some improvements could be made there just to bring that additional certainty. I think that was it. I mean, as far as I was concerned, just to mention, I mean, we will try to do that work, with the usual bodies involved in those exercises. I think I mentioned, if we can, or if LPEA can approach the Ministry of Finance, Justice, HCPF, Luxembourg Bar, Chamber of Commerce, and so on, we will do so. So that's it. I think, Catherine, you perhaps wanted to jump on the HCPF points as well.
Yeah, no, thank you very much. I mean, there was I see that you guys have a lot on your plate, so it's great and lots of very good projects and definitely something to watch. I also hear you that there is a nice request for contributions for the members of the association. So guys, don't forget this. Just maybe just being conscious of time, we wanted to briefly just discuss the RIFE and SICOR, SIF and UCITS, just to cover also the toolbox. But Silke, Manfred, unless you did agree, I think there is not much to say at this stage. The RIFE will be slightly improved, hopefully in a few months. Is there anything worth mentioning at this stage?
Well, from my side, I think I have no spectacular news to bring to the audience today. Yes, we are in our RIFE committee. We are working on the RIFE constantly, so trying to improve both the legal framework and bringing ideas to the government and to the stakeholders of how we can improve the framework, but also looking into best practices. And trying to come up with some market guidance. We actually took the liberty to not only look into RAFEs, but a bit larger to other non-regulated funds and some of the practical difficulties we know our members are experiencing. So we try to take an approach that is really helpful to the market, and we hope to come up with some helpful insight, best practices, guidance, and so on in the months to come.
Thank you, Silke. And now I cannot let you go without talking about the most, and I think the very first action item, because we try to make a circle as to the agenda of the different topics at stake. And well, the very first action item is definitely Brexit. So I don't know, Silke and Manfred, can you briefly run us through the current state of play?
Manfred, you want to go first?
Yeah, I just need to first unmute. I was hoping
You are.
to find the button, but no. I mean, of course, the situation is not easy, and I think all the discussions about deal or no deal, which are currently going on, are anyway not concretely concerning what our business is. But the thing is, of course, what will happen, especially to delegation when it comes to managers acting in the UK. What will happen to the distribution and the marketing of a product towards the continent, which are coming from the UK, and of course maybe that's big importance here, the MiFID items, the question as to branches under certain rules, how can they act in the future? And I think the general statement or impression which can be made as a beginning is that we all have the let's say good feeling that even though there may not be a real deal, that we will have a memorandum of understanding kind of in place, being let's say just put out of the box, but being in place, as we know that this has been negotiated before the last time we were running into a hard Brexit scenario. And I think this is something couldn't, let's say, more or less a little bit rely on, that the delegation to portfolio managers in the fund scenarios will be possible also after the 1st of January, which of course could provide also a kind of a solution for the one or the other currently authorized AIFM sitting on the British island and after 1st of January not having any more formal AIFM license, because you will not be able to have it as it is a third country. So that is one important item I, let's say, wanted definitely to mention. I don't know, Silke, if you want to now jump on distribution, marketing, or we should tackle directly the MiFID, maybe servicing, which is also, let's say, relatively clear.
Well, I think I fully agree with all you've been saying, Manfred. I think on my side, I could certainly not answer what is the right solution for its situation today, because I see every day new information coming in from where the discussions stand and the negotiations, so it does not look very good. I think we have two good points or jokers in our pocket, as I would see it. We have regulators that are really willing to help and find solutions going forward. So I think from all the discussions we've had with the CSSF, they are very much willing to make sure that current models may be in a different shape, but will still work in the future. Of course, they are not legislators, but they are willing to help and find solutions. That is a really important point to me. And the second point goes maybe back to what Manfred told us earlier on the AFMD review. So we know all these discussions on delegation, substance, and so on under the AFMD review. I personally hope, and I'm optimistic, but I hope that with the timing of Brexit coming now and the political heat of the Brexit negotiations currently having probably a pretty big influence on the AFMD review, and AFMD 2 coming only sometime next year, hopefully we will end up with some reasonable framework under the AFMD 2 proposal when it comes up, because by then Brexit will have happened, there will be models in place, there will be things that work, hopefully, maybe others that don't work so well, but I would hope that some months down the road, like summer next year, so we will have a better picture of what is really needed under the AFMD review, and I'm hopeful that this will also give an opportunity to review certain things and come back to a sort of proper sustainable model going forward towards the UK, especially in our space, in the alternative space. So I would just wish to make these 2 positive notes at the end of our session.
Catherine, if I may just quickly add on the MiFID or on the branches topic. The CSSF clearly stated previously that, of course, if you have a UK branch and then you want to re-enter into the market to Europe, that will not work. And a UK entity having a branch on the continent will also, let's say, be limited in using anything else but the branch country. So that is, of course, things which are, let's say, not that astonishing, but have been made relatively clear by the CSSF previously. On the other side, I think for the distribution, for maybe certain periods of not really grandfathering, but acceptance of a certain scenario of transition, I think we let's say, can definitely count on the will to cooperate in that respect. And
Sure.
AIFMD2 is in a number of questions driven, I think, by the situation which was realized due to the Brexit scenario, and we should, let's say, bear that in mind also when we look at the questions.
Mm-hmm. Thank you. That's true. Thank you, Manfred. And I think now it's time for us to move to questions. So I see 2 questions on the chat board. So the first one, I think, Silke, was for you when you were talking about the cross-border distribution directive and regulation. And someone is asking, what about the loss on the reverse solicitation opportunities linked to the new rules?
Yeah, that's obviously a bit of the downside, because whenever you do certain of these things, like if you do pre-marketing, you cannot claim that there is a reverse solicitation, because well, there is a presumption that your investment by that investor in the country where you did pre-marketing is due to that pre-marketing, and then you need a notification. So you're sort of, whenever you go actively into a country and you notify the regulators that you're doing pre-marketing, you cut off, to some extent, the argumentation of reverse solicitation. So it has an impact indeed. And the same goes, as I very briefly mentioned, on the denotification. Well, there are some periods where certain things, including reverse solicitation, are more difficult or barred out. The reverse solicitation is not entirely excluded. It still exists as a concept, and there will be a specific review of the reverse solicitation, how it works. I don't have the precise date in mind, but there is a review provision on specifically the reverse solicitation. So we will need to watch the space, but indeed, if you're doing pre-marketing, you will have more difficulties arguing reverse solicitation. That's totally correct.
Thank you, Silke. And the second question, I think, came, Sebastian, when you were talking about Luxembourg remaining competitive and looking at what others are doing. And we have the question that should not we rather look at our improving? I guess that's what the person raising the question means. Should we not rather look at Ireland corporate law and do revamping of their limited partnership regime, introduction and development of the ICAV?
Thanks, Catherine.
I think we should take that as a compliment.
I'd say yes and no, in the sense that I might not make friends in Ireland for that, but Ireland is revamping its limited partnership regime because we did well in the first place. And I'd say our RAIF was, I think, is based, vaguely based on the ICAV. At least the Irish were the first one to introduce a sort of non-regulated or lightly vehicle regime like that. Then we had the RAIF, which improved on that as well. So I think it's important for them just to look at Luxembourg doesn't to improve, and then conversely we will do that. And I think there will probably be a sort of pendulum effect at some point, which is that other jurisdictions will improve on what we have done here. We have to keep a close eye on that. And we will do and hopefully go a step further as well.
Thank you. Okay, I don't see any other question in the chat board. So, well, thank you very much, everyone. I think just leave me to a few words to conclude. So, a couple of the Director General of the CSSF recently said that the future was going to be sustainable and digital. Will of course overcome the Brexit turbulences, and the AIFMD too will lean in for continuity. So with the challenges now just in front of us, you only need to look up to see the many opportunities of the post-Brexit European financial services industry, be it sustainable and digital indeed. We only have to shape it this way. So the role is ours to take, and I very much hope that we can do this together. So again, you've heard Sebastian and the other. Please do contribute. It's in our interests of all of us. Thank you. And thank you very much to my wonderful panelists today, Silke, Sebastian, Manfred. A huge thank you.
Thanks
to you, Catherine. Thank you.
Thank you
to everybody. Bye-bye.
Bye-bye, everyone.